I'm Colin O'Keefe, and this is LXBN TV. Social games developer Zynga is suing one of its former employees for theft of trade secrets after he allegedly took a hefty chunk of documents with him when he departed for a potential competitor. Joining me now from Chicago to discuss the case is attorney Jason Stiehl of Seyfarth Shaw and their blog, Trading Secrets. Jason, first, what exactly is happening here? What authority does Zynga have to take back control of the data that was allegedly stolen?
Certainly, Colin. First of all, thanks for having me. The complaint is unusual, but interesting. The case is being brought under California's Trade Secrets Act, and so what they're trying to allege here is two things. One, that these documents that have been removed and this information that's been removed are trade secrets that belong to Zynga, basically protective, highly proprietary materials. The second thing they're alleging is that there's a contract between Zynga and its employee that prohibited him from removing confidential information. So they're coming at it from two different ways, both from statutory as well as a contractual basis.
And second, Zynga is no stranger to trade secret litigation, with them earlier this year having to defend allegations that they stole ideas from another game company in creating Farmville. In deposing this individual, is there a possibility that Zynga's own tactics come to light? For example, what if he has trade secrets that weren't Zynga's in the first place?
Yeah, certainly, and I think that's when I said it was interesting. I think that's what makes this case most interesting, is that Zynga is, in essence, opening its doors to a competitor because to prove its claim of misappropriation, it has to prove that it has trade secrets, that its information is confidential, and that it, in fact, developed it itself. As you mentioned, they're no stranger. They've been sued by, either threatened to have been sued or sued by multiple people for having either stolen or copyright infringement or other malfeasance for taking others' ideas and basically trying to incorporate them as their own. In fact, I think there's a quote from a former Zynga employee saying it was the directive at Zynga to basically look at others' ideas and steal them. So it's a fine line, and so by bringing this suit against former employee, they're going to have to prove that what they claim he stole is in fact theirs. And to do so, they're going to have to go back through their own research and development and open the doors to a competitor, frankly, and competitors' lawyers and say, here, we can show you that it's ours. And it's a real risky proposition. If I had to bet, if I was a betting man, I imagine this case will settle rather quickly.
It'll be interesting to see because, yeah, of course, that aforementioned case, it wasn't something where they were just looking at another product and stealing it. They were doing due diligence on this product, so you never know what type of data, Zynga may possess that they may, not want to get out there. So it'll be interesting to see. Once again, that was Jason Stiehl of Seyfarth Shaw and their blog, Trading Secrets. For more on this case, look for it on TradeSecretsLaw.com, and for curated commentary from the LexBlog Network's thousands of authors, visit us at LXBN.com. Thank you, Jason.
Thanks, Colin.